start off and then turn it over to Donna. I had a commissioner call me and asked me to talk to our attorney about issuing an opinion in regards to open meeting laws and how they pertain to nonprofits, and specifically the hospital. Because I do believe there's some, I wouldn't necessarily call it issues, but there are some thoughts out there that the hospital is violating potentially state law in regards to how they hold their meetings, whether or not they should be open. I think a lot of people are thinking that the hospital and not other nonprofits, that could be the BDC or whoever, are obligated to have open meetings similar to this board and other publicly elected boards. You do have enclosed in your packets a letter. It's part of David Lawrence's from the School of Government's book about open meetings. It does, number 11 there, it does talk about nonprofit entities and open meeting laws, and specifically hospitals. And Ms. Shoemate, I'll just turn it over to you to describe what the reading and what the opinion is on that.
Well, as I said, this comes directly from David Lawrence's book about open meeting laws. It's published by the School of Government. And the general rule is if the only connection to local government is funding from a county or city, the nonprofit corporation is not a public body. And there was one question he had in the book specifically on point: what nonprofit hospital corporations are subject to open meeting laws? I know you have it in front of you, you've probably read it, but for the public's benefit, I'll go through what the three situations are that would make a hospital board subject to open meeting laws. First, if the hospital is owned by the county or city hospital district or hospital authority, but is operated by a nonprofit corporation, the operating corporation is a public body if the majority of the board of directors are appointed by the governing board of the county. And that's just simply not the situation that we have. It's not owned by the county, and the county does not appoint the majority of the members of the board of directors for Allegheny Memorial. Second, even if the governing board does not appoint a majority of the members of the hospital corporation, the hospital directors are still a public body if a county or city has outstanding general obligation or revenue bonds issued on behalf of the hospital. Again, that's just not the situation we have here at this point. We have no bonds issued. And then third, if a hospital that was owned by a public entity has been sold to a nonprofit corporation under the conditions of certain statutes, which is the only statute which permits such a sale, the corporation that acquired the hospital is a public body. And again, it was not owned by a public entity that was sold pursuant to this statute. So again, Allegheny Memorial Hospital is not one of the hospitals that would be subject to open meeting laws. Anybody have any questions based on that?
Does the board have any questions? Well, I'm glad to see that he gave this report. I know I've been approached, I'm sure other members of the board have been approached about that very same question. And I didn't have the legal expertise, so I appreciate that. Does anyone else have a comment or a question?
No, but I'll just say, I mean, I don't mind Don saying, I mean, I asked to put, have it put on the agenda because I was approached just like you were. Actually, I looked at the statutes and then, got with Don and asked Donna to, look into them. And, for the public's knowledge, I mean, the Allegheny County Memorial Hospital, just like the county attorney said, does not have to, comply with the open meeting laws. And, just so the people understand that. Because I know a lot of people have asked, both of us, and I'm sure everybody else, so we just needed to clear that up.
Thank you for making your request. That's good. Thank you, Don.